right, we are here in re estate of Harold Wilson, case 29738. Each party will have 15 minutes to present its arguments. Appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and you want to reserve time, let me know when you begin your argument. I'll do the best I can to keep track of time for you. As you know, these arguments are being visually and audibly recorded. They are being live streamed. We have read your briefs and we are ready to proceed when you are. Mr. Hallbauer, you will start whenever you're ready.
Well, I'm ready, Your Honor. Again, I'm John Hallbauer. I represent the appellant Daniel Wilson. If it pleases the court, I would like to reserve 5 minutes for rebuttal.
All right, thank you.
And Daniel Wilson is the nominated executor under his father's last will and testament that was executed in January of 2019, and he was nominated executor in prior wills of the decedent. Unfortunately, Andrew Wilson, Daniel's half-brother by adoption, didn't like the decedent's final provisions for Andrew in the decedent's trust, which is not before the court here, and he filed a will contest and a trust contest action against Daniel and accused Daniel and Daniel's sister by adoption, Erica Wilson, of all sorts of wrongdoing, but nothing has ever been proved. That's a separate case. And the revisions to the trust cut Andrew's share of the estate somewhat, and instead of giving money directly to Andrew, gave money into a trust for the education of Andrew's children, and increased Erica's share of the estate by several $100,000 because Erica is a person who has special needs, has very limited ability to have any income. She's got SSI, I think, and that's about it. And so there's some funding for a special needs trust for her. That displeases Andrew. He has sued. And based on that suit, he filed objections to Daniel's application to be appointed executor as the decedent wanted. And there's no question, there is a lawsuit between them, but that doesn't prove that Andrew is not suitable to be the executor. And suitability is the standard under revised code section 2113.05. And there are some cases that construe suitability, and we submit they're going to support the granting of the application of the nominated executor. Instead of what the magistrate and then after objections, the probate court did and said, no, Daniel cannot be executor. Alternate executors nominated in the will cannot be executor. We're going to appoint some third party to be acting as administrator with the will annexed or something like that. There's a preliminary issue in the case, though, that I want to address for a moment, and that is the issue of standing. That the law requires that if you're going to make a position in a case, and this doesn't mean just on the merits of the case, any position in a case that you're going to assert, you have to have standing to assert that. And standing requires that you have some legal interest that is being affected by what you're trying to prevent or overcome or change. Andrew is not a beneficiary of the will. There's only one beneficiary, and that is Daniel, as trustee of the decedent's trust. Who serves as administrator or executor of the estate can't affect any legal right of Andrew. And that means he really has no standing. We raised this in our first brief to the magistrate. We raised it in the objections to the probate judge. We raised it in our supplemental objections after we had a transcript in the case. And that issue has been absolutely ignored by the magistrate, the judge, and the appellee throughout this case, including in the briefs to this court. But I submit it is a legitimate issue. Every case, if you're going to assert a position, you have to have legal standing to do that. So I hope the court will pass on that issue, and finally it'll have some attention. And standing is interesting because it has a de novo standard for when it's reviewed by the appellate court. It isn't subject to some little bit fuzzier abuse of discretion standard. Now, as to the appointment of the executor, there's no question the law says that's subject to an abuse of discretion standard. That was decided in the Henney case by the Ohio Supreme Court in, what was it, 1981 or something. But that is a discretion in determining the suitability of the nominated executor. There is nothing that is put in evidence that says that Daniel somehow is not suitable. When we read the cases cited by the appellee, where people were determined not to be suitable in the particular circumstances of any particular case, there's always some sort of legal conflict between the interest of the applicant who was determined to be unsuitable and the interest of the estate. It isn't just a matter of heirs or next of kin not liking each other, which is all we have in this case. At least there's not liking by Andrew for Daniel. The concept of reasonably disinterested that some of the courts mentioned, including Henry, that relates to legal interests. There's no interest of the executor affected by him being executor that's adverse to the interests of the estate. And abuse of discretion can sometimes be a little confusing. It means a little bit more than just what the judge feels like. There has to be some reasoning for it. We do cite the Warner versus Waste Management case for that, and there was a good law review article by former Judge Painter in the Ohio Northern Law Review that we also cite. There are numerous cases cited in the appellee's brief. Every one of those we read, we digested, we summarized the facts and show why there was in fact an actual conflict of interest between the nominated executor who was denied and some interest of the estate or some other function that the executor had to perform, like in the Henney estate, where the nominated executor was also presently serving as executor in another estate that was fighting or had conflicting claims to assets of the Henney estate. We have a long quote in our brief from the Nagel estate, which was an interesting case in that the decedent's girlfriend and secretary was his nominated executor, and his wife thought, well, she ought to be the executor. And the court said, no, it was an abuse of discretion not to appoint the nominated executor under 21-1305. There was nothing to show that she had a conflict or that she was unsuitable, we think. And that is just an example of a case where there was abuse of discretion in denying the application. There was also the Ruggles case cited at page 14 of our brief, where the probate court was reversed for an abuse of discretion in denying the appointment of a nominated executor. There was actually 2 executors nominated to be co-executors. The one co-executor opposed the other one because the parties weren't close, and maybe the co-executor didn't even recognize a brother. Of course, that's irrelevant. Excuse me. I'll reserve the rest of my time, if I may. Can we?
Judge, I did have a question for Mr. Hallbar, if I could.
Yeah.
Attorney Hallbar, as to the issue of standing, I'm looking at your assignment of error. How does that fit the assignment of error you've raised in this court? In other words, you didn't say the court erred by not addressing that issue or finding standing. Thank you.
I just say it's automatically an abuse of discretion or an error to make a ruling where the party seeking the ruling has no standing. I think it's a legitimate issue within that issue, or within
All right, thank
the
you.
assignment of error.
I don't want to use up too much of your rebuttal time, but that answers my question. Thank you.
Thank you.
Attorney Oldham, you'll have 15 minutes whenever you're ready.
All right, thank you, Your Honor. I'm Attorney Joe Oldham, representing Applee Andrew Wilson. I'm not going to speak for too long, but I'll be happy to answer any questions you have. I guess the first thing I'd like to say in relation to the standing issue is I don't believe it was before the trial court, and I don't believe it's before the appellate court, and you can't raise it for the first time in oral argument. And even if we get beyond that, this is a will contest case. We're contesting the validity of the will in which my client is not a beneficiary. So you can't say, well, you don't have any standing, because basically then you could never have a will contest, because, you know, the person who's been written out of the will by definition wouldn't have standing under that argument. We're contesting the will, so that argument just, to me, doesn't make any sense, and it's not before the court. In relation to the underlying arguments, the Ohio Supreme Court directly addressed this issue in the In Re Henney case in 1981. And it set out the 3 factors which determine whether or not someone is suitable to be an executor. It appears that appellant wants to just basically ignore that case, talk about the Nagel case, which was decided in, I believe, 1974, before the Henney case, and he wants to focus on the argument that his client is a suitable executor because he's an accountant and, you know, those issues. We didn't raise in the lower court that he wasn't suitable based on his just general qualifications. The issues we argued were in relation to the suitability under the Henney case, and we got into the, you know, enormous amount of distrust and problems between these 2 brothers. And in appellant's brief, interestingly, I mean, you can see essentially the anger that the appellant has towards my client, including making arguments that weren't even brought up in trial, which is that my client's mother, under his appellate brief, basically, he thinks broke up the marriage with his mother and the father of these people, who's the decedent in this case. So he's basically highlighting our argument that there is so much animosity and distrust between these parties that it makes no sense for them to argue that that doesn't exist. And it was certainly within the discretion of the trial court to determine that it's better off to have a neutral third party being the executor or administrator in this case. And, you know, I suppose there's not much legal relevance to it, but there's absolutely no harm whatsoever to the appellant by this happening. We're not changing the terms of the will. We're not changing the terms of the trust. All they're doing is getting a neutral third party to administer it. There's no harm that's to the appellant. He wants to argue that, well, that was my father's wishes. Well, his father's wishes are directly, you know, at issue in this case. his will was changed, about a month before he died at age 91 under very, very questionable circumstances. So I'm not going to go through, the various cases because I think they speak for themselves, and I'm happy to answer any questions that the panel has.
Any questions?
I have no questions.
All right, Mr. Olin, thank you.
Thank you very much.
Mr. Halbauer, you'll have your 5 minutes. You had some time left before rebuttal when you were answering that question, so you have your full 5 minutes.
Thank you, Your Honor. I don't think I'm going to take 5 minutes. To say that standing was not raised below is nonsensical. It was raised in the brief that was filed to the magistrate before we had the hearing on November 13th. Said there's an issue with respect to the standing. It was raised in the objections to the magistrate's ruling that were filed to the judge. There was actually 2 sets of objections to the ruling because we made the objections and then we got the transcript and then we supplemented the objections with making the standing argument. It absolutely was before the probate court. It just got ignored. That was pointed out in our brief to this court in our first appellate brief. And we argued the standing and we made the citations about standing, and it was ignored by the appellee. The appellee didn't counter and argue, well, you didn't raise it below, because we were going to address that in our reply brief and giving you the exact citations of where it is in the record below. But it is in those brief and objections that were filed to the probate court. So we have a new argument from the appellee that it was somehow waived. It wasn't. It was raised. It was ignored. And it's important to note this is not a will contest action. This is an application to get an estate started, excuse me, by having the nominated executor appointed to be executor to handle the probate estate. There is a will contest and a trust contest action that is a separate adversarial action pending in probate court. But that isn't what is involved here. The fact that will contest action is filed against the applicant who is an executor doesn't make him unsuitable to be executor. He is the nominated executor until the person contesting the will in the separate action proves by clear and convincing evidence that somehow the decedent was unable to make a will, and then that would reinstate the prior will of the decedent that nominates the same person to be executor in any event. That's what the decedent wanted. Somehow, Andrew and his counsel can't understand that the decedent didn't want Andrew controlling the decedent's estate. He trusted Daniel, and Daniel wants to do what his father wanted. This concept of there's anger towards Andrew shown in the brief. I mean, I write these briefs. I'm not angry at anybody. I'm just trying to deal with the facts and the law that's at issue in the case. And that's all I have. I submit that this case should be reversed. It was an abuse of discretion to deny the application of the duly nominated executor. Thank you.
All right, any questions?
No.
Thank you both for your presentations. Mr. Halbauer, I might need you to mute. The court will take the matter under advisement and issue a written decision. It'll be mailed to both sides in due course, as well as posted on our website and that of the Supreme Court. All right, thank you, and we will hang on here.